This segment, what I intend to do is give you an overview of the O1 visa process. What I suggest is that if you can watch the other segments after you watch this, and then come back and watch this again, hopefully the ideas will make a little bit more sense. But I'm just going to give you a quick overview now of what's involved in an O1 visa. An O1 visa is a non-immigrant working visa for aliens in the arts. There's actually 3 types of O1 visa. The scope of this segment is about aliens in the arts. That's the focus of what I'm doing with these videos. In order to qualify for an O1 visa, you have to have a petitioner. A petitioner is an employer or a U.S. agent. If it's an employment relationship, it's similar to other visas like H-1B, where you have a company that wants to hire you, and you're going to be an employee of that company. There's a few other elements that you could have in an employment relationship that I'm going to get to a little bit later in a separate segment. A U.S. agent is someone, or it's a company that represents an artist if they intend to work with multiple employers. So in order to get an O1 visa, you have to have a petitioner. You cannot self-petition, but that would be the first element of what you need. The second element is if you qualify, and the third element is if you have an itinerary of events to confirm what you're going to be doing in the United States. In order to qualify for the visa, you have to be extraordinary. What does that mean? USCIS, in the regulations, they talk about distinction and prominence. Prominence is being leading or well-known in the field of arts. That's pretty vague, so it's a little hard to know what that means. They have those general keywords as an idea, and then what they actually do is they have a checklist of different categories in order to qualify for the visa. The first category would be national or international prizes or awards. And you can either be nominated for that award, so you don't have to win the award, or you have won that award. The regulations refer to either a Grammy, an Oscar, or an Emmy. So it's a pretty high standard. But if you do satisfy that standard, then you essentially do qualify for the O1 visa, and you don't have to satisfy the other categories. The downside of that is because it's such a high standard, USCIS is going to be pretty rigorous in reviewing whether you qualify, and there's a good chance that if something isn't necessarily a national or international award or prize, if it's not clearly one of those prizes, then USCIS will have a negative feeling about the application. The other categories, so there's 6 other categories, and essentially if you don't qualify under the prize category, then you need to satisfy 3 out of the 6 other categories. And I'm just going to run through those quickly here, and then what I will do is in future segments I'm going to break down each category and give people ideas of how they qualify in each category. The first category is leading or starring participation in productions or events that have a distinguished reputation. What does that mean? An event is a time-based occurrence. So if you do something like an artistic exhibition, a lecture, if you're on a panel, that occurs in a specific period of time, and that is an event. The event has to be distinguished, and that's something that we'll talk about again later. So, and you have to have a leading or starring role in that event. So there's a few elements that are involved in that category. A lot of artists do satisfy that category. The second category is the language is critical reviews or other published materials about the beneficiary in major newspapers, trade journals, magazines, or other publications. The key word here is major magazines or newspapers or trade journals. It's a pretty high standard, and so there's a differential between people that have local media attention and something that would be considered major, and that's something that is not the easiest thing to accomplish, but it's something that people can work towards, and it's really a key, in my opinion, is the biggest element in how USCIS determines if someone is prominent, because if someone is prominent, they should have major media exposure. Another category is a leading, starring, or critical role with organizations that have a distinguished reputation. This can be documented with letters of recommendation, testimonial letters, and it can be supported by press or portfolio evidence. And the key really is critical role. And the idea is that if someone has a critical role with an organization, if they're really helping that organization, then they can potentially satisfy that category. The next category is major commercial success. And that is, it's essentially public information. If someone has a box office success, if they have motion picture or television ratings or other achievements that are public information, then they have commercial success. Obviously, certain occupations are favored in this category, such as film and television and music, and not so much for other categories. Although I have seen artists and designers have best-selling books, so there are situations where someone has commercial success. Another category is significant recognition for achievements from either organizations, critics, government agencies, or other recognized experts. This is a category where recommendation letters can count a lot. You don't necessarily have to have other evidence besides recommendation letters in this category, although there are ways of improving this category even more. The recommendation letters are essential to succeeding in accomplishing the visa categories, because some of these other categories are essentially materials that exist. You could call it organic materials, and this is something that can be manufactured in the sense that you can prepare letters of recommendation to satisfy that you have significant recognition for achievements. The last category that I'm going to talk about is high salary or remuneration, and essentially some people have it and some people don't. So if, for example, if you are a architectural designer or you're a designer and your salary is, say, $150,000, you might be in the top 10% compared to other people in your field. And if you have that high of a salary, then you might satisfy this category. If someone's an artist, they might have art sales that could be documented by an accountant or an art gallery. So sometimes people do have high salary. The other advantage of this particular category is if it's an employment-based petition, you can have a situation where even though a person hasn't had a high salary, they will be having a high salary in the future. And if that's part of the petition, then that's actually a category if someone intends to pay you a high amount of money. If that's the case, then essentially you just have to prove two other categories and you're very close to qualifying for the visa. As I mentioned a little earlier, there's some material that's organic and there's some material that's manufactured for these visa applications. Organic material exists in the world. So if it's a newspaper article about an artist, that's something that already exists, versus a letter of recommendation describing either a critical role or significance. This is something that's manufactured for a case, and they both are important. The next thing that I'd like to discuss is assignments and contracts. And so essentially, in order to get an O1 visa, USCIS says that you can get a visa for either an event or a series of events. If something is a employment-based petition, like if you're going to be an architect in a firm or a designer working for a company, essentially you would make an itinerary, but your itinerary would be a repetition of your job description, that you're going to continue working on that assignment over the 3-year period. If you're an artist or a designer that's working with a U.S. agent, or you're essentially coming up with your own contracts for assignments, then essentially what immigration is looking for, they're looking for confirmed assignments over a 3-year period. And that's something that's not the easiest thing to do. It's something that you can work with your attorney to document that immigration is not interested in someone freelancing. In other words, they're not interested in someone coming to the United States to look for work. They want you to come with an itinerary of events that are backed up by contracts, and when you do that, the events should be for the full 3-year period. Otherwise, you can get a visa for a lesser period of time. And so this is something that we're going to get to in a later segment, but it's something that's required. Once you have it figured out that who your petitioner is, that you do qualify, and that what you can document what you're going to do in the United States, then essentially the attorney fills out certain documents. There are forms called the I-129, which is called your petition. A G-28 is a form to show that you're being represented by an attorney. An I-907 is another form that's required sometime for something called premium processing if you're trying to speed up the process. The attorney will prepare a cover letter of all of your evidence to describe why you qualify for the visa. The attorney will prepare an agreement, or the employer might have an agreement that will describe the terms and conditions of the employment. If it's an employment-based petition, if it's a U.S. agent-based petition, the U.S. agent will provide you with an agreement to explain what the representation is involved. If you have a U.S. agent agreement, then you will need other contracts to document what you will do in the United States. The attorney will prepare an itinerary of all of the events that you have documented, and those are all of those things that I just mentioned are essentially the petition forms. The petition forms are signed by the petitioner, whether that's an employer or U.S. agent. The artist will sign an acknowledgement of those documentation, and then these materials would go to one of two entities. You would either get a no objection letter from a union, or you would get an advisory opinion letter from an expert. So the USCIS regulations say that if there's a union in the occupation, you have to get a letter from that union that the union does not object to this visa application. Certain unions are very strong. For example, the Directors Guild, Actors Equity, and they might not want to approve an application. Other occupations, I wouldn't say a formality, a mere formality, but it's something that is not as difficult. Other unions would be, for example, the American Federation of Musicians, IATSE for photographers, or the Graphic Artists Guild for designers. Once you get that letter, then you're ready to send the file to immigration. If you send it by regular filing, it's really going to depend how long it takes. Essentially, for many years, files were taking about 2 or 3 weeks to be approved, and they can take as long as 3 or 4 months. And so that's really going to depend, and that's something that you would need to talk to your attorney about. There's something called premium processing, where you can spend an additional fee, and the USCIS will review your file within 2 weeks or 15 days. And there are reasons to do that and reasons not to do that. It depends on what your itinerary is and what your budget is. Once you send the file to immigration, one of 2 things would happen, or actually one of 3 things could happen. You could either be approved, you could be denied, or you could receive a request for evidence. If you're denied, then that's the end of that petition. It doesn't mean that you can't appeal if you disagree with immigration. It doesn't mean that you can't file again, which you can, but that's the end of that application. If the case is approved, you will proceed to a consular interview, or if you file to change your status in the United States, then the approval will essentially document your new status in the United States. If you receive a request for evidence, essentially what that means is that there's something about your application where USCIS is not feeling satisfied that you immediately qualify for the visa, and they will give you feedback about how they feel about the application. And sometimes it has to do with the petitioner, sometimes it has to do with the events, and sometimes it has to do with the credentials and whether someone is qualified as being prominent. So essentially what you would do at that point is you decide if you want to withdraw the application, which people do occasionally, or to respond to the request for evidence. If you respond to the request for evidence, then immigration will do one of two things. They'll either approve the case or deny the case. So ultimately, if you do get a request for evidence, this is something that you have to talk to your attorney about to make a decision what to do. The final step, as I mentioned, is consular processing. So if someone is in the United States and they opt for consular processing, they would go back to a U.S. consulate in their country or in another country. So essentially, there are some consular forms to fill out. It's called a DS-160, and this is something that's normally reviewed by an attorney. And the applicant goes to the consulate with a copy of their file and certain other documentation, and they have an interview, and that consular officer will review their credentials and make sure the person's eligible for the visa. So there's essentially 3 people that are interested in each applicant from an immigration perspective. The first person would be the immigration officer at USCIS who reviews the initial petition. The second person would be the consular officer who reviews the application in the U.S. consulate and interviews the person to make sure they're eligible for the visa. And the third person is the USCIS officer at the airport when you return to the United States. They can all ask you questions. They can all be concerned about whether you're qualified for the visa. And ultimately, you have to be prepared for all 3 people in order to succeed in getting the visa.